And I think that for people who do choose to remain for the entire time, and then need to exit the upper lot and access the lower lot, it's very easy for us to present the ride when they sign in with a diagram and directions explaining how they can get to the lower lot, and that we don't recommend that they make a left or left.
Thank you.
I just wanted to respectfully also remind the board, the immediate abuttor to the south is Walgreens. Walgreens has 61 parking spaces. And I believe the logic that tells strict generation from the CVS is far clear. This
I
board,
think he actually just testified that it's less than actuality. And I think what he's telling us is they actually don't use it. No, I think
excuse me,
no
I'm
perspective.
speaking about your question was coming out on Harvard and making a left. That's what I'm
You can do that from the Walgreens parking lot, which is right next to the parking lot.
And that is much closer to Aspen.
No, I understand.
And that was approved by the board.
And this board approved it, so I'm slightly puzzled by what is it that we're generating here on total traffic, which is the concern. Thank you.
Just one, because I have not actually overthought. Is there no connection between public court and Aspen?
In fact, it is. I don't know if legally it goes through. There is a fence across it at the back of the Star property. Our access rights are not that extensive, so we couldn't go out.
Yeah, however, there is a connection between Harvard Court and Aspen Wall, and that is through Walgreens.
Thank you.
I also wanted to speak to the board about my letter which I sent yesterday concerning the excessive parking extent. This is what I'm trying to focus on, is really the zoning issue that is before the board with respect to excessive parking. As I set forth in my letter, Chapter 48 of the Zoning Act of Massachusetts requires uniformity, and they do that by saying that if you divide districts into divide a city or town into districts, the uses in those districts have to be uniform. Every property owner is similarly situated. So the Brookline zoning bylaw follows that uniformity requirement and sets forth uses which are permitted as of right, including medical office use, which we are, and then it also includes other uses which only may be permitted by special permit. And the reduction in accessory parking spaces is a use which is only permitted by special permit. The fact that the principal use of the building is for medical office use doesn't change or affect the analysis of whether a special permit should be granted with respect to a reduction in parking. The town has made a decision, essentially, that medical office use is permitted at this site as of right. And it isn't within the purview of the planning board, of the zoning board, to bring into consideration with respect to section 9.05 of the zoning bylaw, what the principal use is going to be. What the board needs to look at is, are these parking facilities an appropriate use of this property? As I mentioned, for over 35 years, this building has been in place and these parking areas have remained essentially unchanged. The building jacket for this site includes a plan which shows the parking lots in their current location, more or less spaces perhaps, but the spaces I think at that time were 9 by 19, some of the space sizes. As recently as when I think it was a pizzeria restaurant was here, they came in, sought relief from the parking requirements because they wanted to add some tables. This board granted There was some concern on the part of the board that there wasn't enough parking for customers here. And the decision indicates that the owner or operator testified that during the lunch hour it wasn't so much of a problem, but at night, if there was a problem, he would send an employee out to direct parking in this lot. So this is a situation where the parking use has been much more intensive. We haven't changed, and we're not proposing to change any location of parking areas. And the questions under 9.05, which I go through, evidence that there is, that we meet all the criteria. This is an appropriate place. There have been previous decisions of there are memoranda in the building chapter from the building commissioner at the time saying that the parking facilities comply with all of the zoning bylaws. The use of this area as a parking, for accessory parking, is appropriate, and it won't present any serious hazard to pedestrians or vehicles. There isn't any report of accidents at either the site driveway or harbor port over the years that this configuration has been in place. And if there had been, I don't think the board would approve Walgreens using harbor port as a secondary means of egress, and it wouldn't approve what apparently it did was approve this as egress for 86 parking spaces over in St. Paul. In terms of the aisle widths and size of the parking spaces, number of handicap spaces, number of compact spaces, those are all appropriate and adequate for the proper operation of an accessory parking use. So I think the board needs to consider that the accessory parking use, determining whether it satisfies the conditions, it has nothing to do with the medical office use, which is permitted as of right. I don't know if the board has any questions on those issues. I'd be pleased to answer them. The other aspect of my letter was with respect to questions which were raised by one of the citizens about aisle widths and size of the spaces. We've gone through that. The aisle widths do comply. All the parking spaces, space sizes comply. There was some perhaps confusion on the citizens' part in terms of the depth of the aisle spaces. As the zoning bylaw provides, you can count 2 feet of the overhang in determining the appropriate aisle depth,